In November of 2019, Nathan Nash, a Spokane police officer, was charged with the rape of two separate victims. These rapes took place while he was on the job. In both cases, these women were already victims of other abuse cases. The jury convicted Nash of third-degree rape and second-degree rape. Nash is appealing his convictions, arguing he was unduly prejudiced by joinder of the two unrelated cases, meaning he argues they should have been tried separately. He also argues the court abused its discretion by excluding information about one of the victims' mental illness. Let's take a look.
And the second case on today's docket is State versus Nash. And let's see, both attorneys are appearing via Zoom. Let's see, use my glasses here. The appellant's attorney, Mr. Parker, you will be up first. Please introduce yourself and let us know how much time you'll want for rebuttal.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Corey Parker and I represent the appellant, Nathan Nash, and I would respectfully like to request 3 minutes for rebuttal.
Okay, you may begin.
Thank you. Your Honors, the trial court's granting the motion for joinder of the charges involving each complainant unduly prejudiced appellant by giving the appearance of propensity to commit sexual assault while on duty. I want to start out notably with State versus Harris, which stated that prior sexual offenses have great potential for prejudice, and State versus Ramirez. Both the Harris and Ramirez cases involved sexual offenses where the court recognized the, quote, great potential for prejudice inherent in evidence of prior sexual offenses. The prejudice potential of prior acts is at its highest in a sex case. So I wanted to remind the court of this important.
Mr. Parker?
Yes.
Let me ask you a question. So how do we balance that then with the very liberal policy of joinder provided by the rule?
I definitely understand that question, Your Honor, and I would respond by looking at the case law, right? Looking at Bluford, the Supreme Court case, Washington Supreme Court case that was cited by both parties, Harris and Ramirez, both essentially showing that when there's two sexual assaults involved or two incidents of two cases, they have to qualify as links in a chain forming a common design scheme or plan. They can't just show a propensity, right? That's a violation and it's prohibited by ER 404B. And so the case law under Harris has said that showing that there's a propensity for the person to commit this potential crime doesn't qualify for joinder, regardless of how liberal it is. The court has been, the Washington Supreme Court and the various court of appeals have emphasized the importance of sex cases in particular and how there is definitely more of a caution as it relates to those. And
Mr. Parker?
Yes.
We, of course, aren't the ones that you're arguing this to as trial judges. Can you identify the standard of review that we're looking at as Court of Appeals judges? And I think it's important for us to review the facts that were before the trial court at the time the trial court made the decision. So what's the standard of review? At what point in the trial court, at what point in time did the trial court make the decision? And what were the facts before the trial court at the time they made this decision?
Certainly, Your Honor. So the standard of review is abuse of discretion. And there's four factors in determining whether joinder will cause prejudice.
And that's kind of the same as the factors that the trial court considers from the beginning. But my second part of the question is, at what part of the trial did the trial court make this decision?
Yes, Your Honor. The trial court made the decision at the beginning of trial. And so there was, argument in the briefing about severance and whether a motion should have been renewed for severance. But it's our argument that Washington Supreme Court and Bluford adopted Division I's approach, saying that joinder simply has to be brought up at the beginning. That joinder and severance.
Right. So we're looking at joinder, not severance. Correct. It's reviewed for abuse of discretion. It was made at the beginning of trial before testimony. So what facts were before the trial court, before testimony occurred as to joinder? Can
Yes,
you
Your
walk
Honor.
me through that?
Yes, Your Honor. So for TP in particular, the victim TP, there was DNA evidence in the information. So I'm talking about the information, not the trial. DNA evidence suggesting that sexual contact, but appellant was arguing consent. In that case, also the appellant in the information conceded being at her home. The appellant's cell phone put him at the location, and there was no mental illness of the victim alleged under TP's matter. KT's matter can be distinguished from that. In KT's matter, there was no DNA evidence. There was a general denial by defense. It wasn't a consent argument, it was general denial. And KT was diagnosed with a severe mental illness, notably delusions. And the defense wasn't allowed to show that she's made similar reports that were unfounded, but they could show that the defendant had another allegation against him. The report was made 2 years after the incident, and there was no evidence that appellant was present at home. There was also a story about kind of misinformation about when the actual incident occurred, that the time in the information was incorrect. But I understand, Your Honor, and we're certainly not arguing here that the court should have taken into consideration what happened in the trial or any of the testimony. We're simply looking at what was in the information, and when they made at the time of making the argument, the court, had that evidence, those facts that I just noted in front of them, and those shows that the cases were distinctly different, especially as we look at Harris, as we look at Ramirez. Arguably, the cases were even further apart in Mr. Nash's case than they were in the aforementioned cases.
Was this,
Go
go
ahead.
ahead, Judge.
Mr. Parker, I have a question for you. You had said that this motion was made right before trial started, but my information is that the motion for joinder was made on August 16th, 2021. Isn't that correct?
Yes, Your Honor.
And it was based upon the affidavit of facts, basically the affidavit of probable cause that was submitted and attached to the prosecutor's motion. Is that correct?
That's correct, Your Honor. Yes.
Okay, and when I'm reading through those statements of fact, there's nothing in there about DNA.
Your Honor, it was my understanding that that was discussed in the information, and my apologies if I had that wrong, but it was my understanding that there was an understanding that there was sexual contact, and that they were at the very least extracting DNA or in the process of DNA, where we knew conclusively in KT's case there was no DNA evidence whatsoever. So I understand that more developed when the trial began, but at the time, the affidavit, it was my understanding that there was mention of DNA or the acquiring of DNA, and that they were in that process.
Okay. But evidence that was gathered or presented to the court after August 26, 2021 would not be relevant to our analysis. Do you agree with me?
I agree, Your Honor. Yes. I do.
Okay.
Your Honor, if I may, I think another important consideration here is the giving of a proper jury instruction. That the court specifically stated that they noted at page 183, 184 of the transcript that a limiting instruction would be beneficial, and that factored into its finding on factor 3. But then the court never went on to give this limiting instruction. The court never stated to the jury this.
Did the defense counsel propose it?
So we argued that in the brief, Your Honor, that we didn't expect the court to sua sponte bring this up, and you're right, the defense did not argue it, but we believe that the judge, the court opened the door by stating part of the reason they're making this decision was specifically on the finding on factor 3, that the court that a limiting instruction would be beneficial, that the court should give a limiting instruction. And with respect to the evidence, the court didn't make the instruction that evidence of one case cannot be used to determine, the guilt or potential guilt on the second one. And so that was, something that, again, the court, in its conclusion that it was going to join the cases, provided that as an important component of it, saying that it was going to it was going to have this jury instruction, and then it didn't follow through with doing
How
it.
does that factor into an abuse of discretion at the time of the motion? So at the time of the motion, the court says, I'm going to give this instruction, and then later on doesn't give the instruction. Isn't that just a separate assignment of error instead of the court abused its discretion at the time?
We would argue, Your Honor, that the court abused its discretion in not giving the limiting instruction, and then to show support for that, we're stating that with the court's prior statement, that in making its determination. But I
And
understand.
it could be that my notes are incomplete as to what you've argued on appeal. Is one of your arguments on appeal that the court, an assignment of errors, the court failed to provide an instruction?
It is argued, Your Honor. It is argued that the court.
It's not one of the assignments of error.
Correct. I don't believe so off the top of my head, but no, I believe that we argued it, and we believe it was fully argued in the brief to be considered that the limiting instruction, was manifestly prejudicial. That in any case precedent regarding this type of issue regarding joinder, you're going to see that limiting instruction, and the court noted as much, and it wasn't in this case. It looks like I'm running low on time here, but just briefly with respect to the second issue, Your Honors, this was a very unique, I guess, circumstance or a circumstance where KT not only just had some mental health issues, but had hallucinations, delusions. There was a significant amount of specific evidence of her stating that she was Jesus, her saying thanks to the doctor for giving her medication, and the doctor testified to this. Now, I understand again that wasn't part of the trial, came after the joinder motion when Dr. Potter testified, but the trial court only allowed evidence that KT suffered from delusions, but the jury didn't have the broader, richer evidence about all of the kind of the supporting evidence there. And that would have, we argue, was an abuse of discretion, that it very well would have made a difference to the outcome of the case. And again, to balance that with the unfairness of the defense has this prior incident that goes before the jury, this allegation, whereas he doesn't get to provide the allegation of the victim here. And her behavior is pretty troubling with respect to the delusions, the hallucinations. The jury should have been privy to that in order to make their determination, especially since there was no DNA evidence, especially since there was a general denial defense on that. That's something that the court, abused their discretion in not allowing in. And I think, my time is almost up here. I'll save the rest for rebuttal, but I appreciate the court's questions. Thank you.
Okay, thank you. Response?
Your Honor, may it please the court, I'm Gretchen Bierhoff, and I represent the state of Washington in this matter. The state is asking this court to affirm Mr. Nash's judgment and sentence. As this court has already noted in the argument, the two arguments that Mr. Nash is making are subject to an abuse of discretion standard. And that's a heavy burden for the defendant to meet, because the defendant must show that no reasonable judge would make the rulings that these judges did.
Ms. Bierhoff, our audio is not great, and as a result, I don't know what is going on. If you could slow down, I think that would help. It's not that you're in general speaking too fast, but I think it will help with the audio if you're just consciously trying to speak slowly.
Okay, absolutely, Your Honor. So the state was saying, Your Honor, that these claims are subject to an abuse of discretion standard, which is a high burden for the appellant to show, because the defendant must show that no reasonable judge would have ruled as these judges did in this case. So before I launch into why the court's rulings were not an abuse of discretion, I would like to correct a misstatement that is in my brief, in the in the respondent's brief. At page 79, I said, and this is in the context of the evidentiary ruling, I said a single isolated comment regarding KT's alleged belief that she was Jesus, made over the phone to a non-testifying witness months before she encountered Nash and years before he allegedly raped her, was not relevant. That was a misstatement. It should have said months before she encountered Nash and years before she alleged he raped her. So I just wanted to correct that for the record. My apologies on that. Turning to the first, the joinder issue, I think as the court has noted, and as I pointed out in my brief, what the court must focus on is what the trial court knew at the time of the joinder motion. The joinder motion was heard over approximately a year in advance of trial. And Judge Hazel, I believe, had only the probable cause affidavits and the arguments of the parties. I do think it's also notable. Judge Staub, did you have a question?
I do. And
Okay.
so instead of interrupting you, I'm just going to raise my hand.
Okay. My video of your honors is this little tiny box, and you're all in one little box. So I I wasn't sure if you were trying to get my attention.
So my question is, my understanding of the record at the time the motion for joinder was made is that there was no DNA evidence. At least I didn't see any in the affidavit of facts. Do you know if there was DNA evidence on, was it TP?
You know, Your Honor, as Your Honor asked that of Mr. Parker, I could not recall that. Obviously, that came out later. And going back through the state's joinder motion, which is at CP, I'm looking at CP 258. I don't see that that was a fact that the state relied on at that time. I could be wrong, and it might have been something that was brought up during oral argument. But I would note that even if there was DNA in the TP case, you know, the defendant had always alleged that this was consensual, and I believe that was in his interviews before charging with the police department. So you know, there wasn't really any question that the sexual contact occurred in that case, even with or without the DNA. I would note, though, that with regard to KT, I do believe that there was evidence at the time of the joinder motion regarding the KT's knowledge of the back tattoo. Although I could be wrong on that. So, you know, there certainly was evidence that actually, yes, on 258, the state did assert that KT her statement was corroborated by her knowledge of his back tattoo, which was not visible when clothed, and was not located by the detectives on any social media or internet forum. So that was certainly a corroborating fact that I think weighed into the court's calculus about the strength of the state's case on that count. Returning to, you know, what I understand Mr. Nash's argument, which is that there's undue. Yes, Your Honor.
I had a question. Yeah, I guess our audio is poor on both sides. For me, the most compelling of the four factors is cross-admissibility, and partly because if the evidence is cross-admissible, then it's kind of moot, and obviously you need instructions and all that. Could you walk me through, though, why there's cross-admissibility? If you were arguing this case and for whatever reason you couldn't have them tried together, what are your arguments for cross-admissibility under 404B for each case as to the other?
Yes, Your Honor. Under 404B, the evidence of other acts is admissible to show a common plan. And so if I were arguing this, and as the state did argue this below during its 404B motion, the evidence that Mr. Nash engaged in a certain plan prior to committing each of these offenses, in shutting down his new world, in with regard to KT's case, in checking to see if other officers could see where his vehicle was located before he then met her.
I just want to make sure that all of this was before the judge at the time. So are you limiting it to what was before the judge at the time these evidence was there? Just wanted to make sure.
Yes, that evidence was before the court at the time. And I would just make sure to clarify that when the court considered the joinder motion, when Judge Hazel considered the joinder motion, he actually and sort of oddly reserved on the state's 404B motion. And so the state actually then re-raised its 404B motion at the time that the defendant moved to sever the charges. So then you have Judge Cooney reviewing the motion for severance at the same time he considered the 404B motion. So one of the state's arguments here is that because the 404B motion was considered at a time separate from the joinder motion, any error in Judge Hazel's ruling finding that there was a common plan, there's no assignment of error to the separate 404B motion. And so as Your Honor noted, it would be a harmless error. So I do think that it is important to understand sort of the timing that all of these things happened. Another thing that I wanted to point out with regard to KT's mental health is that at the time of the joinder motion, it appears that there was an indication that she had mental health problems. But when the court goes through the record, it will note that the subpoenas for her mental health records did not occur until December of 2021. So 4 months or 3.5 months after the joinder motion was heard and decided. So none of the parties had access to the records about the so-called Jesus statement. None of the parties had the in-depth records about her mental health condition. So that did not factor into the court's calculus at the time of the joinder motion. Does the court have any other questions about the joinder issue?
If you could go back to, I interrupted you where you were in the process of making the 404B. I still think it's important for us to first consider what was before the court at the time of the joinder motion. You started to go into that. Could you finish that presentation up on what the 404B analysis would have been at the time of the joinder decision?
Before you get into that, I just want to jump in as a preliminary issue because I'm not quite understanding the separate arguments between joinder and 404B because 404B is one of the factors to consider in joinder. So can you explain to me why was the 404B motion relevant only if joinder was not granted, or why is it still relevant after joinder is granted?
Well, it's relevant, Your Honor, because at the time of of Judge Hazel's joinder ruling, he specifically reserved on whether or not the evidence was cross-admissible. That's at page 563 of the clerk's papers. So while he found
So is that abuse of discretion? Is that abuse of discretion given it's one of the factors? I think it's the most important factor, cross-admissibility.
And I would certainly say that it's unusual, but I think he wanted more information than perhaps what the parties argued, and perhaps he wanted more information about some of KT's issues. I don't know from the record. I don't know. What I can say is that he found that there was enough there to find a common scheme or plan for purposes of the joinder motion, but then he wanted additional briefing for the 404B as to whether the evidence was actually cross-admissible. So my argument is really...
Yeah, because once they're both being tried together, it's no longer 404B evidence, it's just evidence of the crime under trial.
Well, yes and no. I suppose that there could be a limiting instruction that says you can use some of this evidence only for common scheme or plan, but you can't consider it for any other purpose. And that probably should have happened in this case, but didn't. And that's because the defense counsel didn't ask for that instruction. So returning to Judge Pennell's question regarding the common scheme or plan in the ER 404B ruling, the state's argument was really that that this was a common scheme or plan because Mr. Nash devised a plan and used it repeatedly to perpetrate separate crimes. And that's one of the means of showing a common scheme or plan under ER 404B.
There was a table included in the prosecutor's motion that compares the two crimes. Is that relevant to this analysis?
Absolutely, Your Honor. That table was actually included in the state's briefing on the 404B argument. So if the court looks at CP 265 and 266, that's where the state outlines all of those factors that at the time that the motion was made, this is the information that the state had, and were the reasons why the state submitted that this was a common scheme or plan. So that included, making a follow-up contact with the victim for purposes of taking photographs. Those photographs were never actually taken. Didn't
the trial court actually expressly adopt those findings as part of its order?
Yes.
And so not only were those arguments made, but those factors were important for the trial court's decision.
Yes, Your Honor. The court did specifically adopt those factors. I'm not seeing where it is, but Your Honor is correct. The court did specifically and importantly, he did independently verify those assertions based on the probable cause affidavits. He made a point to say that, he didn't just trust the state say so on it, and that he went back and independently reviewed the pleadings that had thus been filed.
So even if Judge Hazel expressly said he was holding off on making a 404B decision, sounds like the findings he made adequately addresses a lot of these concerns that there was a common scheme or plan.
Yes, Your Honor, and he did make a finding that the evidence was admissible in the joinder ruling. He did make a finding that it was admissible to show a plan. So I don't know why he reserved the 404B ruling, but he made the ruling at the same time. And so, the state submits that yes, Your Honor.
So I have a question just procedurally then, given that he reserved on that and that Judge Cooney later granted the state's motion for cross admissibility under 404B, do we, in our analysis under joinder, for that particular factor, do we look at what evidence was available to Judge Cooney? If there was additional information available, or are we only looking at Judge Hazel's decision?
I think, Your Honor, what the court does is for the joinder motion, the court looks at what Judge Hazel knew at the time. The state has argued that Judge Cooney's later ruling demonstrates the harmlessness of any error because that evidence was coming in as cross-admissible anyway, even if the cases hadn't been joined. Did the court wish to hear any sort of comments regarding the mental health evidence? I see that I'm almost out of time. No, all right. Unless the court has any other questions, I would ask the court to affirm.
Okay, rebuttal, please.
Thank you, Your Honors. We would ask the court to reverse in this case, and we've talked a lot about abuse of discretion and that's a high standard. Well, in assessing whether or not there is abuse of discretion, this court should look at precedent. And specifically, we'd ask the court to take a really strong look at the State versus Harris case cited in the brief, the State versus Ramirez case, and the State versus Bluford case. And in those cases, there was a similar analysis completed by the trial court where they determined whether or not there was in fact a common design scheme or plan. And Appellant argues that the common scheme or plan determined in those cases was even weaker, in this case, it's even weaker than the common scheme or plan in those cases. And in those three cases, the court did in fact reverse. The court deemed that there was not, that it was in fact an abuse of discretion, that it was unduly prejudicial to the appellant in those cases, and they did reverse on those bases. Here again, we even with the evidence that the court had before it, at most, again quoting Harris, at most they show only a propensity, proclivity, predisposition, or inclination to commit the crime, but such evidence is explicitly prohibited by ER 404B. And so, it also the state in that case urged that both evidence in both cases were necessary to prove the absence of a mistake or an accident. But in that case, the defendant didn't claim mistake or accident as a defense. And so the reviewing court determined that that wasn't a good enough reason to have a joinder, to have a common scheme or plan. The same applies here, regardless of the DNA evidence. We have one case where there was a alleged where consent was the issue. We have another case where there was a general denial. So there wasn't a link in that respect. And again, to argue, as the state has, that, well, this was a police officer who, wanted to commit a crime like this while on the job, that's at most, again, like Harris, shows propensity. It doesn't show a common scheme or plan as is required by this. And again, just want to restate that in sex cases in particular, there's a higher burden here. The courts have, unanimously come to that conclusion. The Washington Supreme Court has said that sex cases, there's a higher standard here. This is the defendant's life, his liberty, and we're asking for the court to again really take a good look at those cases and determine that there was in fact an abuse of discretion, regardless of whether two judges made the same call. It seems like there was maybe some confusion at the time. Things were muddled when they were making that decision, and so we would ask your honors to please reverse and allow Mr. Nash to have a new trial where where the cases are in fact separated and not joined to cause this type of confusion and prejudice that it caused during this case. Undue prejudice, I should say. Thank you.
Thank you. The case has been submitted.
In September 2024, following these arguments, the court found no error and affirmed the trial court's decision. Nash must face his 14-year sentence. Is this enough time for a police officer who victimized women he was sworn to protect? Let me know what you think in the comments below. Please subscribe to see a new court video every week. Watch Laws Evolve and be entertained. Until next time.